on the basis of weight. We have a kind of vehicle, and we have a name of vehicle. It is interesting to note that the name and kind of vehicle does not specify any weight in it. There is absolutely no mention of weight in the name and kind of vehicle. I will take, for example, my lordship. If we see section 2 clause 21, my lordship, may please see the act now.
Have you formulated it, Kaustubh?
My lord, I have
what you're saying,
my
have
written
you
submission, but
formulated-
in a very short form. But I'm just expanding it, my
No,
lord.
no, I'm just asking, have you formulated what you said? No.
Yes, ma'am.
You've given us written submissions?
There is, my lordship. But my lordship, what I am right now argument is beyond my written submission.
Yes, you got
Okay,
it.
then you can go
So-
ahead.
Now tell us, just to take it forward, you
Yeah.
are saying there
There
are three categories.
This is section
Class
2
of
clause
vehicles,
21.
what class of vehicles based on weight? Just give us which are those provisions so that we can
Yes,
just
ma'am,
take.
please. Section 2 clause 21 first, it is for LMV, which is up to 7,500.
Just do the numbers.
Yeah.
Yes, yes.
221, then?
216 and 217, 223 and 224. And all these definitions are very perfectly interconnected, my lord.
Okay, now, so far as those vehicles which are go by name, non-weight, what are
yes,
those?
sir.
A kind of vehicle without reference to weight. That's the
Yes.
second thing. Which is that?
Yes.
Kind of vehicle without reference to weight.
My lordship, first is the transport vehicle,
Clause.
247. There is a tourist vehicle, 243. There is a tractor, 244. There is a semi-trailer, 239. There is a private service vehicle, 233. There is omnibus, 229. There is motor car, 226. There is a motor vehicle which is in general definition 228. And there is goods carriage, 214.
214.
Yes, sir. So, Malashmi, see in all this,
These are kinds of vehicles without reference to weight.
without reference to any weight, there are kinds and names of vehicle without reference to any weight.
Names and names.
So,
Together.
the main benchmark for identifying a class of vehicle is weight. And after the definition provisions, the whole act has to be interpreted considering the weight of the vehicle. Before that, my lordship, I will just point out by way of an example at how perfectly it is interconnected. If my lord may please see section 2 clause 21, which means a transport vehicle, as defined in 247. Now the transport vehicle means a public service vehicle, which is also defined as to what is public service vehicle. And public service vehicle also finds mention in 217, which is the heavy public motor vehicle, and also finds mention in medium public motor vehicle, medium passenger motor vehicle. So it finds mention in a weight category between 7,500 to 12,000, which is a medium public motor vehicle, and it also finds mention in the weight category above 12,000, which is the heavy public service. So much likewise, even the education institute bus. Let's take the other example in the definition of 247. So the education institution bus also find mention in 217, which is the heavy public service vehicle, and it also find mention in 224.
What you're saying is there is no very, very clear distinction between vehicles based on weight and vehicle based on name and,
It is very clear distinction
Right.
only on the basis of weight.
so they are all integrated. So what's the sequitur?
So much like the significance is going to be the interpretation of the further provisions in the act based on the definition. So as per the bird's eye view about the definition clauses, the definition is primarily a basic classification on the basis of weight. We have a classification up to 7,500. We have a classification from 7,000 to 12,000, and we have a classification above 12,000. The interesting part is that everything which is defined is already defined in the uh, in the definition clause, as well as it's mentioned in the class. So definition is also there, and the very same kind of vehicle also find mentioned in the class. If I am able to make my
Which
point.
is the category of 7,500 to 12,000?
It is a medium. My lord, may please read 223, for example. Means any goods carriage, so much goods carriage is also find mentioned in 247. Means any goods carriage other than light motor vehicle or heavy goods vehicle. So light motor vehicle is up
To
to,
7,500.
and
These
heavy goods
above
vehicle is
12.
216 above. So there is a very perfect categorization. And in order to further expand the example, let's take the another example from the definition of light motor vehicle. Let's say omnibus. So much omnibus finds mention in the category of light motor vehicle, but omnibus also finds mention in 270, which is the heavy passenger motor vehicle. And omnibus is also defined in section test what exactly is omnibus. It is defined in 229. So much likewise, the kind and name of vehicle which is defined in the whole definition scheme of the act has nothing to do with the weight. Weight is a separate classification altogether. Because we find a very common name in across the class of all the vehicles. If I'm able to also satisfy my lord. Therefore, my lordship, let's take example of motor car also.
What you do is, you have good points you have raised. But
Formulated
that doesn't
for us,
seems to
okay.
be existing in the written
I
concept.
will
Reformulate it
Yes, I will definitely.
along with these sections and then give it to
I
us.
will
And then give it to us.
because all these sections are very much interconnected.
No, I know, you are,
I will
you are,
just put it
you are
down,
drawing it
please.
in a different kind of a scheme. You formulate it for us.
I will do it, my lordship, and I will. And therefore, the definition has to be seen in a bird's eye view. It can't be seen in isolation. The definition of a transport vehicle, all only a definition of a light motor vehicle.
You have given us
Every-
that now, those classifications, yes.
Because every word mentioned in the definition of light motor vehicle is already defined in the other provisions.
Anything else? Give it to us.
Yes, my lord.
About 2 or 3 more pages
Well,
linked to your own submission.
the-
And share it with the others.
But other part is, as far as to understand section 3, 4, section 3, 4, 5, and 6. Actually, what we need to understand first is section 7. My lord, may please see section 7 for a moment. It is the restriction on the grant of learner license for certain vehicles. So it specifies that it is the restriction for grant of learner license for certain for a certain vehicles. And what are those certain vehicles is to be inferred because the word uses transport vehicle unless he held a driving license to drive a light motor vehicle for at least 1 year. So like if a person wants to so basically, if a person wants to apply for a
Let's not militate against your submission. That means you
E-
can't get a learner's license for a transport vehicle unless you have a light motor vehicle license and you have held it for 1 year.
light motor vehicle, as per the definition, which include a transport vehicle up to 7,500.
Right.
So it is very clear that so like the basic restriction which
You are saying
section 7 is talking about.
7 also read it as exceeding 7,000.
Because it has to get measured because the word transport vehicle is already defined in section 2. And therefore, the most appropriate interpretation in my submission will be,
So you are trying to, therefore, this section will have to be recast.
yes,
No person shall be granted a learner's license to drive a transport vehicle, bracket, which does not fall within the definition of a light motor vehicle,
Yes.
bracket complete, unless he has held a driving license to drive a light motor vehicle for at least 1 year. So we'll maybe reading in some provisions into the statute.
so because the plain reading of Malfi, this section says that a person is already having a,
So Devrat was saying that interpret 10(2)E also in a different way, therefore. So you're now saying, look, 7 also will have to be, will have to be slightly structured in
because
interpretation.
the person is going to apply, he's already having a driving license so it is therefore.
Only if your transport vehicle exceeds 7,500 in weight, that this prohibition in section 7 comes into effect.
Yes, but if a person is applying for driving a transport vehicle above 7,500, because the word light motor vehicle is here. Hit the word, so Malaysia, they have consciously put the word light motor vehicle here. So they've consciously put the word, and Malaysia, a person must be having for 1 year. So a transport vehicle, as per section 7, is a transport vehicle which is above 7,500. It is not a transport vehicle which is having the same meaning as LMV.
Give us the, this.
Yes.
So really
So after-
speaking, we will have to rewrite all those provisions of the statute now, including those for medical certificates, etc., to mean that those will apply to only those categories of transport vehicles where the weight exceeds 7,500.
Actually, my next part is on the medical certificate also. And so much, if we read the Malaysia section 8 and 9, if Malaysia, we see the pattern, like in which Malaysia section 8 and 9 has been drafted, we see a very similar pattern. Up to proviso number 6 and 7 of the respective sections, they deal with the transport vehicle. And after the proviso, they deal with the light motor vehicle. And my lordship, if we read subsection 1, which says that it is subject to restriction mentioned under my lordship, section 7. If my lord may please read the first proviso of my lordship, section 8. Any person who is not disqualified under section 4 of the driving motor vehicle and who is not for the time being disqualified for holding, obtaining a driving license may subject to provision of section 7. And Malosha, interestingly, if my lord would see the subsection 3, it says every person to drive a transport vehicle under subsection 1. So my lordship, basically subsection 3 is taking you in a reverse gear to my lordship, subsection 1, and the subsection 1 is taking you to subsection 7. Because my lordship, it actually talks about the application. Basically section 8 and section 9 are, my lordship, they both have been drafted in a very similar pattern. It is very important to observe the pattern in which sections are also drafted. Because like section, section 8 clause 1 and 3 takes us back to section 7 in a very similar manner. Section 9 clause 3b also takes us back to section 8 clause 3. And accordingly to the restriction, as far as a person is already having LME for a period of 1 year, only after that he can apply for
formulate, Mr. Shukla, you formulate now your submissions. I think we'll close. We got the drift of your submission, but I would like to see a formulation by you. Yeah, give it to us. We'll reflect
there is
on it.
the other part of the submission is that
because this is just typically one of those matters we require a written formulation, because
I will like, because it
interplay
is
of
because
intricate provisions,
The
it's
other part-
basically statute.
it has been drafted in a very well interconnected way.
So
I will
formulate it.
I will
give it to us.
Job, Kaustubh.
Because you would like to think over it, but just give it to us so that we can then
Yes,
have
yes.
something on paper which we can.
What
Yes.
else, Kaustubh?
Anything
I will
else?
do that. I will do
Thank
that.
you.
There is also only 2 points which actually I want to make.
Just indicate, indicate.
Yes. So as far as the definition of section 10, 10 to D and 10 to E is concerned, it also has to be read considering a very holistic view of the definition clause. It is my very short submission. The much other part is with respect to the rules. So because my lordship, it has been
Just
pointed-
formulate it, what you are saying on the rules, what do you have to say on the rules?
As far as the syllabus part is concerned, my lord, rule, my lordship, 31J, if my lord may see.
What is
they-
your-
they-
what is your
There
formulation?
is, my lordship, no syllabus for a transport vehicle. The my lordship, syllabus is only for my lordship, light motor vehicle and my lordship, medium oblique heavy motor vehicle. There is no syllabus for transport vehicle. Therefore, to say that there is a different syllabus, it is, my lordship, not in consonance with, my lordship, rule 31J, rule 31J itself.
All right, thank you.
Actually, my lordship, in my written submission, I only just want to point out because my lord is more concerned about the impact of this judgment, my lordship. If my lord would please see my written submission. The my lordship, concept of my lordship, third party insurance is introduced as per chapter 11 of the Act. It was introduced in the year 1994 by way of Amendment Act 54. And if my lord may please see page number 3 of my written submission, my lord. As per section 49, my lordship, which falls under chapter 11, its main object of the amendment is
Page 3.
page number 3, my lordship, my point number 5. Its main object is to provide the adequate compensation to victim of the road accident without going through the long drawn procedure. It is the main object of 1994 Act, and it is therefore there are two kind of insurance, my lord. One is a statutory one is a statutory insurance, which is as per chapter 11 of the Act. They have to have the statutory. They need to have the statutory insurance, my lordship. It is a compulsory. It is a compulsory third-party insurance as per the Act. It is not a contractual insurance, my lordship, where we take a comprehensive policy for my lordship, everyone. It is the statutory insurance. And thereafter, my lordship, the my lordship, chapter 11 was further amended by way of an Amendment Act of 32 of 2019. And as per clause 2 of the statement of object and reason, the main purpose was, my lordship, to basically further, my lordship, quantify the loss of the family by losing its breadwinner. It is very categorically mentioned the object of the amendment.
I think, Costa, what we should do is, you have some good ideas. You will have to redo your written submissions.
I will do that, my lordship.
You reformulate this.
And my lord, for a simple reason that it is a basic law that the contract of insurance is a contract of indemnity.
All right.
So pain recovery, my lordship. The page number 7 is the pain recovery, my lordship, because this Swarna Singh judgment is a good law
All right.
as on date, and only the part which is, my lordship, basically I am worried, my lordship, with respect to the pain recovery, because it is a settled law as on date. The 150 defense which they are talking about is, my lordship, subject matter of trial. They can take a defense, it is a valid defense, but the defense has to be proved before, my lordship, MSCT. And what we need to understand, my lordship, most of the MSCT matter, my lordship, like the victims are underprivileged. And it is therefore the amendment of 1994 and also 2019 is in a way of beneficial legislation. And accordingly, the rules of interpretation has to go. So I will not expand on that because my lords are very clear.
My lord,
Please, ma'am.
appearing in 501.1 and the formulation which my lord was referring to I might provide some assistance there, both regarding the weight and categorization. It's a name of Anuj Bhandari, my lord, 501.1 written submissions.